This is Dr.P.Syamala from the Department of MBA, IB, Acharya Nagarjuna University. And today's topic is regarding the conditions and grounds for registration of trademarks. In previous class, we have learned about the concept of the trademarks and the types of trademarks. Okay. Now, in this class, we are going to learn about the what are the conditions or what are the grounds for registration of these trademarks. Okay, so all these will be studied under section 6 to 17. Okay, under this we'll study about the objection of trademarks also. Okay, so coming to this, the grounds of registration or else the conditions regarding the registration of trademarks. Before going to this grounds, we all know that trademarks is nothing but trademarks means any sign or symbol which is an identity of goods and services which are offered by any person or any enterprise. Okay, so these trademarks are the intellectual property of the user of the trademark which are used in trade and commerce. So these trademarks basically they shows some connection between persons and the enterprises. Okay, so trademarks represents the intellectual property of the persons who are using those trademarks. So protection may be at national level or international level depending upon the owner of the trademarks. Okay, so protection is given through trademarks, and we all know central government deals with all these trademarks. Okay, and the head offices will be declared by the central government also. If we see in India, the head office will be at the Mumbai and the branches will be at Delhi, Calcutta, Chandigarh and Ahmedabad. And if we see about the uh, conditions and grounds for these registration, a trademark may be we all know that we have a registered or unregistered trademarks. Okay, so in previous class only I have said for registered one, it will be like this, R means it is a registered. Okay, and if it shows TM means it is this is unregistered, or else if it shows SM means it is also unregistered, but this is related to the goods and this is related to the services. Okay, so if we see trademarks may be registered or unregistered, so the legal remedies against infringement are provided for both these registered and unregistered trademarks, and the registration after prima facie evidence of ownership of trademark can be seen in the registered trademarks. Okay, so whereas if we see in non-registration, the user of the trademark has to establish the prior use and passing off. It is nothing but passing off is nothing but previously from long back, since a long period of time when we are using our product. Okay, so people are habituated to our product, people recognize our product. Okay, so for those products also considered as unregistered trademarks. Okay, so when if at all any infringement happens means, okay, so depending upon the case, depending upon the facts, okay, the prima facie will be taken depending upon the prior use of that particular product. Okay, so basically if we see trademarks means they may be either registered or unregistered ones, and the if at all any infringement happens in both registered and unregistered cases means it depends upon the evidences they have been produced. Okay, so the whole subject of the registration can be explained in two parts. Okay, one is the conditions and the other is the grounds for registration, and procedure for registration also includes here. But in this class we are not going for procedure of registration. We are just learning about the conditions and grounds for registration. Okay, in the next class we'll learn about the procedure of registration. So first we will discuss about the conditions and grounds for registration. Okay, so if we see registered, first one, register of a trademark. Okay, if we see this thing, register of trademark means all trademarks which are accepted for registration are entered into a register maintained by the registrar. Okay, so here registrar is the person who will register the trademarks. Okay, so all trademarks are accepted for registration under the provisions of the Trademarks Act, according to the Act, and under the repealed Act of 1958. Previously we have Trademarks Merchandise Act. Okay, so that act in the year 1958, this act was repealed by the Trademarks Act 1999. Okay, and under the repealed is nothing but this act was replaced. Okay, so this act was replaced by the 1999 act. Okay, and before that, in this 1958 Act, the register was divided into two parts, like Part A and Part B. Okay, but now after the existence of the new Act, okay, after the replacement of the new Act 1999, this practice, okay, a single register is now being maintained. Okay, so it shall be lawful for a registrar to keep the record wholly or partially in computer, floppy, or any electronic mode. The registrar has to safeguard the trademarks. Okay, so this is about the register of trademark. Sorry, not registration, register. Okay, register of trademark. So here in this register book, all the trademarks will be registered by the registrar. Okay, now if we see the classification of goods according to section 7 and 8, how the goods are being classified. Okay, so the registrar who will classify means the registrar will classify the goods and services. As I said before, we have trademarks separately for goods and separately for services. Okay, so the registrar will classify those goods and services separation as far as may be in accordance with the international classification of goods and services. Depending upon the international classification, our registrar in our country will classify the goods and services for the purpose of registration. So as I said, here we have to register our trademarks in the registrar office. Okay, so there, according to, depending upon our good, either it is a good, either it is a service, depending upon the good or service, it will be registered in the registration of the trademarks. Okay, any question arising as to class within which any good or service shall be final will be declared by the registrar. In which class we have to consider those goods, in which class we have to consider those services, all will be decided by the registrar. And the registrar may publish in the prescribed manner. An alphabetical index will be followed. Okay, to register our trademark. On what basis they will register our trademark means, depending upon the alphabetical index, they will follow the register in alphabetical index. Okay, and classification of goods and services, where any goods and services are not specified. If at all, if any class of goods or services are not specified in this register means, okay, so those classification of goods and services will be shall be determined by the registrar. So according to the discretion of the registrar, those class of goods which are not in the register will be determined by the registrar specifically. Okay, if you see the duration of registration, okay, when an application for registration is made to the registrar, first of all he may accept or refuse. Okay, so after having accepted the same, if the conditions so demand, means if if the trademark, when we are going to apply for a trademark, means, so if at all our application is according to the provisions of the Trademarks Act, means the registrar will accept our application. If at all there are any objections, means he will refuse. So he will examine the application. If at all there are any objections, means definitely the examiner will object on certain ground. He will specify the ground also, refusal of ground also. Okay, and he will give a notice to that particular, he will mention to that applicant, okay, regarding the ground of refusal. So the registration of a trademark is initially made for a period of 10 years. Okay, so after 10 years they will again go for a renewal, okay, from time to time. So depending the register office, they will intimate to the applicants, okay, to renew your trademarks. Okay, then specifying the fees, specifying with the fees and the time, within this time you have to pay the amount, means they have to pay the renewal fees, and then again they have to renew the trademarks. Okay, so if the proprietor, for example, fails to uh, comply the notice which is sent by the registrar for renewal, then the registrar will remove the trademark from the register office. Okay, depending upon the time. Okay, so if at all the time is expires, means our trademark is also expired, means that particular trademark will not be in our name. Okay, so duration is 10 years. It will be intimated by the registrar office. Within the specified time you have to pay the renewal fee and you have to renew your trademark. Okay, if at all the proprietor fails to comply with the notice and conditions, then the registrar will remove the trademark. Okay, now, if we see the relevant factors to be considered by registrar, means while giving or else while granting the trademark, so what are the conditions or what are the factors that has to be considered by the registrar, means every trademark is not registrable. Okay, so for obtaining registration, a trademark has to fulfill the conditions laid down under the law. So in other words, registration may be refused if trademark is covered under prohibited grounds. Okay, if at all our application is not according to the provisions of the Trademarks Act. Okay, so depending upon the prohibition grounds, the examiner or else the registrar may object to the trademark application for the trademark. So these grounds are further classified into absolute grounds and relevant grounds. Okay, so what are the prohibited grounds regarding the trademarks, means, okay, we can divide those categories into two types. Okay, one is absolute grounds, okay, absolute grounds, and the other one is the relevant grounds. Absolute grounds is nothing but which shows the intrinsic value. Okay, and the relevant grounds are nothing but the conflicting grounds. So depending upon the absolute grounds and relevant grounds, the examiner or else the registrar will prohibit or else object to the application. Okay, so the sections regarding the absolute grounds and the relative grounds are absolute ground deals with section 9 and the relative grounds deal with section 11. Okay, so on which grounds objection can be made by the examiner or else by the registrar can be studied under these aspects. Okay, so if we see in later on slides we will learn about the absolute grounds and the relevant grounds. Okay, as far as now, first one is absolute grounds for refusal of registration according to section 9. So first one is under section 9, following categories of trademarks shall not registered. Okay, so all these points, okay, all these will be considered while giving or else while accepting the application of trademarks by the proprietor of the company. Okay, so the registrar has to look over all these things. If at all these things, the mentioned things does not satisfied, means the registrar or else the examiner, he will not take the application. Okay, he will object the application on all these grounds. So if we see the first aspect, which are devoid of any distinctive character, so we all know that trademark will be given depending upon the distinctive character. Why? Because the distinction between two products or else distinction of our product with the other competitors can be it has to be seen. So the clear difference should be known. Why? Because the consumer should not be confused about all these products. Okay, so therefore the trademarks, in order to get the trademarks, the product or else the goods or services need to have a distinctive character, which is nothing but the uniqueness should be there. So if at all, whenever, for example, I have applied for the trademark, okay, so for my goods or service, if there is no distinctive character, means, okay, so on this ground, the examiner may object our application. Okay, so distinctive character should be there. If at all there is no distinctive character for our goods or service, on this ground examiner will object our application. If we see another one, which consists exclusively of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or the time of production of goods or rendering of services, or other characteristics of goods or services. Okay, so if at all uh, the goods and services or else the person who is applying for trademarks, depending upon these characteristics like the kind, quality, quantity, intended purpose, values, geographical origin, etc., on these basis, if at all the goods and services have all these or else any of these characteristics, intention means, okay, so refusal of trademark will be there. Okay, means the examiner will object the application. Okay, so if we see, for example, intended purpose here. Okay, so intended purpose means, for example, uh, I went for registration of trademark for my product for as pill for a headache. Okay, so I want to register as trademark as headache pill. Okay, so here the intended purpose, the purpose of the product is to clear the headache. Okay, so but we should not go for registration of trademark on the name of headache pill. Okay, means directly the purpose should not be mentioned, intended purpose. Okay, so for example, if we see means the name is different, the name of the pill will be different, but not uh, directly they will say that this is a headache pill or else this is something other. Okay, so if at all they mention that this is a headache pill and they want to register on a trademark on that as headache pill means objection will be raised. Okay, likewise for example, if we see uh, customary language, okay, or else current language, customary or current language means uh, or else the origin. Okay, so if we see for example for this customary or current language, uh, I want to register. Okay, that my product as I want to register my product as Kashmir Kesar. Okay, so I am applying for trademark as Kashmir Kesar means then the registrar office of trademarks they will not register, they will object. Okay, why? Because the origin depicts of a particular origin. Okay, we are depicting a particular origin, the place. Okay, the geographical origin, so we are depicting the geographical origin there, so we should not mention particular origin or else the value, particular quality. Okay, like that we should not mention. If at all if we mention the place like this, as I said in this example as Kashmir Kesar means, so they will object, trademarks will not be obtained. Okay, so indications, okay, which have become customary in current language, they are not considered by the registrar office of trademarks. Okay, so if we see absolute grounds for a refusal of registration means, okay, so in which on what basis the registrar will refuse means, if at all it doesn't have distinct character, okay, they will refuse. If at all that particular good or service depicts the origin of the product or else the intended purpose of the product or else the quality of the product, quantity of the product, likewise. Okay, or else the customary in the current language means, so all these will not be accepted. Likewise, if the nature of the goods or service deceive the public or cause the confusion means, okay, if at all by using that particular product, okay, it will not else by using that product, by seeing the trademark of that product, if by seeing it the public may deceive. Okay, if the nature of that trademark implies or else it impacts the confidence of the public, it will impact, it will deceive the public means, or else it will cause confusion in the public means, in such cases also, okay, objection will be raised or else the refusal of registration will be there. Okay, for our product, for our goods or services. And if we see it contains or comprises of any material like hurting the religious susceptibilities. Okay, so if at all that trademark, if we went to register or any on any aspects regarding which hurts the religious values, okay, then in such cases also they will not register the trademark. Okay, likewise scandalous or obscene matter means, so which is a very which is not good for the public. Okay, so in such cases also, okay, uh, trademarks will not be obtained. Okay, and it means that marks shall not be registered if there is public deception or else scandalous or else emblems and names also in this issue also. For example, if I went for a registration of trademark for my good or service in the name of Ashoka Chakra, okay, I just want to give name of Ashok Chakra, then the trademark office, okay, they will not accept, okay, in the name of Ashoka Chakra, they will not, because it is the national emblem, okay. So according to the Prevention of Improper Use Act 1950, the emblems and names will not be allowed for the registration of trademarks. Okay. Now, if we see the shape of goods which results from nature of goods themselves. Okay. And the same shape of goods which is necessary to obtain a technical result. Shape which gives substantial value to the goods. In all these cases also, we cannot go for registration of trademarks, okay. Like the on the shape of the good means it depends upon the nature, it depends upon the technical aspects, it depends upon the value, okay. So all these also will be considered by the registrar. For example, in shape of goods, shape of a test tube, okay, we all know the shape of a test tube. So if I am going to register a trademark for a test tube means they will not register on the shape of test tube, okay. So likewise, uh, all the aspects regarding the shape of goods they will consider, okay. So however, if a trademark before making an application has acquired distinctive character as a result of the use made of it or is well known trademark, the registration shall not be refused. See, the above cases are all the cases that the registrar will object or refuse, okay. But in only one case which is known as well known marks, okay. So in this well known trademark, the registration shall not be refused, okay. Here the registration should be made to the particular person, okay, provided that here uh, the well-known trademark means, see, it should be a substantial segment of the society. Well-known mark means it is already from since long back years, it is known by the some substantial segment of the people, public, society, etc. Okay. Likewise, in the same way, that particular good or service is in use of search mark for other goods or services, okay. uh, and duration or else the geographical area, extent of use of mark, okay. uh, all will be considered in this well-known trademark, okay, because from many years that good or service, anything, whatever it may be, it is in a process, okay. It is known by the certain section of people, certain section of public, and it is considered and it is situated or else or its origin is in a certain geographical area, and there is a certain extent of use of market for it, okay. And also it is recognized by court in any situation, okay. So whenever all these features are there means it is considered as a well-known good or service. So we can say that it has well-known mark, even though it is not registered, it comes under unregistered trademark, okay. So it is considered as a well-known mark. So whenever it is a well-known mark, okay, so therefore the registrar cannot refuse, okay, to register it for the trademarks, okay. This is why, because why even though it is not registered, why it is taken into consideration means in order to prevent unfair use of that good or service, or else to prevent from harm to reputation of that particular mark of the good and service, or else in order to prevent consumer confusion, definitely that particular well-known trademark should be registered. Okay, in such cases the registrar may not object to register. Okay, so therefore that is about the well-known trademarks. Okay, well-known trademarks should be protected and recognized in all trademark classes of goods and services. Okay, but certain points or criteria should be considered by the registrar while registering that well-known trademarks. Okay, so likewise he should not also consider certain aspects while registering those well-known trademarks. Okay, the well-known trademark is registered in India or not, or else the application is filed in India or not. Okay, or else the trademark has been being used in India. So certain issues, it should not be considered, those should not be considered by the registrar. Okay, so well-known trademark means it is nothing but from a long time it is being used by the certain section of society or a public. Okay, and at the same time it is being also used by the public. Okay, but only to object the well-known trademark depends upon the registered or unregistered mark. Okay, it depends upon the two well-known trademarks, depends upon two categories. Okay, depends upon the whether it is a registered or else unregistered. Okay, so registered means we can see similarities are there or not, distinctive qualities are not, so depending upon those registration will be done. So if it is an unregistered mark means, so we can say that it is seeking for registration. Well known mark is the under this unregistered trademark, it is seeking for registration. Okay, so it is not registered, but it has been what to say, it has been accepted by the court. Okay, so it has some reputation, it has having some reputation, it is being used since long time. Okay, but protected by law. Okay, so that is unregistered marks, and this can be registered by the registrar. But even though objection is raised in opposition in both these registered and unregistered categories. Okay, but depending upon the provisions that were in the Trademarks Act. So that is known as well-known trademark. Okay, so next one is limitations as to color, section 10. Okay, so a trademark may be registered either subject to limitation as to certain colors or any combination thereof. Okay, or without limitation of color. Okay, so here this says, section 10 says about the trademarks registered with color. Okay, if at all they have not registered with color means, then how it is considered means it is deemed to be registered for all colors. Okay, so that is the thing here. Limitation to color means a trademark may be registered subject to certain limitations, that we are registering this trademark with this color, specifically this color. So if at all we have not explained, if at all we have not specified the colors means, then how come it can be registered, the trademark will be registered means it can be deemed to be registered for all colors can be considered there. Then Relative grounds for refusal of trademark registration. So as I said before, we have two types. Okay, one is absolute grounds, other one is relative grounds. So under absolute grounds we have seen all these aspects, and under relative grounds these aspects will be seen. Okay, so under relative grounds, first one is marks which are identical or similar, okay, to an earlier trademark, and the respective goods or services are identical or similar. Okay, so if I went for register my goods or services trademark, means those goods and services should not be identical or similar to any other person's goods and services, okay, or else in previously they should not be there also. Okay, so whenever I am going for trademarks registration, means okay, so my goods or services should not be identical, should not be similar to earlier trademarks. If at all there are already there, means we cannot register. Okay, so another one is the earlier trademark is well known trademark. As I said before, it is already existed. Here I have said, I've told you that well known means it is previously from long back years. It is known to substantial section of people. They are using it. It has a certain reputation for that. Okay, so even though it is unregistered, it is protected by law. Okay, so in such cases earlier trademark is well known means, so the we can consider that where the goods and services, or else the person who is going for trademark registration is doing unfair advantage, is taking unfair advantage of the earlier mark, and would be considered as detrimental to the distinctive character or repute of the earlier trademark. Okay, so it is considered as against to the provisions of the Trademarks Act. And third one is its use in India is liable to be prevented by virtue of any law of passing of protecting. This is nothing but, see, in this case only we will see well known trademark. Passing of protecting means it is previously existing from long back. Okay, since long years that particular good or service is in existence. Okay, it is being used by the people, it is being known by the people, that product has certain reputation. Okay, and also it is protected by law. Okay, even though unregistered, so that is known as passing off protecting an unregistered trademark. Okay, used in the course of trade, or its use in India is liable to be prevented by virtue of law of copyright. Okay, even though it is unregistered, due to its existence from long back years. Okay, and is being used by certain section of people, and is having certain reputation. Okay, so it is prevented by the virtue of law. So in that case also we cannot go for trademark registration. Even though if we went, it will be on grounds of this passing of protecting, refusal by the registrar will be made. Okay, if we see another under grounds of honest and concurrent use. Okay, so this is also under the same one, the relevant grounds only. Okay, so if we see the honest and concurrent use means, this is under section 12. If we study this, the registrar may permit registration to more than one proprietor. Okay, actually trademarks are given to one person. Okay, but here if we see the registration to more than one proprietor of the trademarks which are identical or similar, irrespective of earlier registration, even though it is earlier registration is there for the uh, uh, goods or service, the trademark is registered. the registrar has the right to issue the permit, to issue the or else to issue the trademark, okay, on the ground of honest and concurrent use, okay, on the special circumstance, nothing but honest and concurrent use, he may he may issue the trademarks, okay. So what does this the section says means, it permits the registrar, he permits registration more than one proprietor of the trademarks, okay, means for a single one more than one proprietor will be a trademarks will be given to more than one proprietor, okay, even though the goods or services are identical, even though the goods and services are similar, even though irrespective of their earlier registration, in specific special circumstances, the registrar will permit on the ground of honest and concurrent use, he will permit, okay, provided, okay, provided that while on the basis of ground of honest and concurrent use, while the registrar is permitting means, he should consider the following matters, okay, all these should be considered and then he should permit for on the ground of honest and concurrent use, okay. So if we see what aspects the registrar has to consider means, the extent of use in time, quantity and area of the trade. First of all, he should see the, so he has to see how much time it is going to be used, what is the quantity, area of trade, geographical place, okay. So all should be considered and then he has to allow. Then the degree of confusion likely to ensure from the resemblance, okay. So if the degree of confusion is not that much, okay, so then in such cases also he can consider, or else if it creates more degree of confusion means, he will not give the trademarks on the basis of honest and concurrent use. Likewise, honesty of concurrent use. So, depending upon the honesty of the person who applied for registration, okay, of the use of that one, okay, without any wrongful intention, okay. So in that case also he the registrar may permit. And whether any instances of confusion have in fact been proved, if at all there is any confusion is there and that is proved means, then he cannot permit the trademark. And at the same time, the relative inconvenience which would be caused if the marks were registered, if at all the registrar feels that by giving on the basis of on the ground of honest and concurrent use, if he grant the trademarks means, so if it creates inconvenience means, if he thought that it creates inconvenience means, both the goods and services means, he may not permit the trademark, okay. Or else if it doesn't create any inconvenience means, he can issue on the ground of honest and concurrent use. But if a person deliberately knowingly uses similar trade, okay, if he intentionally deliberately knowingly uses that specific similar trademark means, in such cases, if at all the registrar know that thing means, he will not consider the honest concurrent user and he will not permit that person. Names of chemical elements or international non-priority names not registerable. So these are also not registerable. International non-proprietary names or else chemical elements. These are not acceptable. So no word, okay, no word shall be registered as a trademark, okay. What are those words means? Chemical compound, okay, and international non-proprietary name. So these are not registered as a trademark. So chemical compound means, as for example oxygen, uranium, likewise certain chemicals, they cannot be trademarked, okay, for our name, on our name. Okay, so these in respect to chemical substances or preparation or which is declared by the WHO. Okay, so those are not registerable and notified by the registrar also from time to time as an international non-proprietary name. So those international non-proprietary name also considered. So those are also not registerable. Okay, which is deceptively similar to such name. So deceptive means here, deceptive similarity means here relative grounds will be considered. Both are similar means in such cases also they are not registered. Trademarks are not registered. For example, so two persons, okay, registered means one person registered as Bubble, another person want to register trademark as Double. Okay, so both pronouns like similar only, Bubble, Double. Okay, so in such cases they are not registerable. Okay, so non-proprietary names. Okay, international non-proprietary names. So similar names, deceptive names. Okay, deceptively similar means so similarities should not be existed there. Okay, uh, not only not only on names wise also, so the pronunciation or anything, shapes. Okay, anything, goods without identification. Okay, so they are not registerable. Okay, so names of chemical elements and international non-proprietary names are not registerable. And the last one is names and representations of living persons or persons who recently died. So both are also not registerable. Okay, so falsely suggesting a connection with any living persons or else a person whose death took place within 20 years prior to the date of application for registration of the trademarks, the registrar may, before he proceeds with the consent in writing of such living persons or as case may be, of legal representative of the deceased person to connection appearing on trademark may refuse to proceed. Okay, see, if there is an application made for registration of trademarks giving false representation or else falsely suggesting a connection with any living person or dead person means, then the registrar before when he proceeds, okay, he will ask the consent in writing of living person or else that particular died person consent will be made, asked. Okay, in case of this death person, consent will be given by the legal representatives. Okay, so that consent will be taken. Whenever consent is taken from those persons, then only he will permit the application. Okay, so if at all the consent is not given by the applicant means, in such case, okay, the registrar he will not register the trademark. Okay, unless and until the applicant furnishes the registrar with such consent in the writing form. Consent should be in the written form. So the reason for why they are excluding the names of the living persons or dead persons means, what is the main reason means, to avoid and prevent commercial use. Okay, so basically, only thinking of the economical wise, profit wise, only commercially they are thinking means. So, in order to avoid that, these names and representations of living persons or persons recently died are not considered. Okay, they are not registered because such names on the ground of emotional relationship, they will go for commercial use. Okay, so therefore for that reason they are also not registered. So these are all the conditions or the grounds that are considered, okay, for registration. Okay, grounds of registration means, so Basically, if we see absolute, these are two important: absolute grounds and relative grounds. Okay, so one is section 9 and the other one is section 11. Absolute grounds is regarding with the what to say means similarity of distinctive character. Okay, distinctive character of the goods or service, or else the exclusive of marks. Okay, it depends upon the well-known good or service, depending upon with respect to the kind, quality, or purpose of the product. Okay, and also it is related to absolute grounds are related to customary and established mark. It should not be confusing. Obscene matter should not be there. Okay, religious hurting of religious aspect should not be there. uh, Emblems and names are prohibited here. Okay, shapes are also considered. Okay, so all these are related to the absolute grounds where refusal of registration is done. Okay, if we see in relative aspects, means relative aspects, under relative aspects, likelihood of confusion should not be there. Well known product. Okay, well known good or service, how it is, on what basis it is considered. And here prohibited under some law by copyrights, if at all there is any well known good or service. Okay, and similarity of goods and services will be considered here. Then if at all there is similarity of goods is there, identical, they both are there, them are identical, then in such case also registration will not be done. Okay, likewise international proprietary names or chemical elements are involved, means, so in that case also registration will not be there. So deceptive similarities should not be there. All these are considered as the relative grounds. So this is about the grounds, conditions for registration of trademarks under section 6 to 17. Okay.